So, Scott, obviously a lot of, incredible rulings over the past week. You wrote a piece earlier about how unpredictable things can be after following the death of Antonin Scalia. But let's start with what is perhaps the biggest ruling. I think it's fairly safe to say that. We had a major ruling on abortion, which how would you characterize this in terms of it being surprising? Because it seems to me that this is pretty surprising, this case involving HB2, which is a Texas law that was, and I think the court found it to be a law that was set up to specifically to restrict abortion, but not ostensibly so. So, just lay out the case for us.
Well, you can look at, and I was literally, as we speak, was just filing. I have an article that by the time listeners hear this will have come out on the website Democracy, the web magazine, basically trying to explain how Justice Kennedy has shifted. And I wasn't entirely surprised that Kennedy finally went, had been pushed too far. So basically, the Texas law, passes an array of targeted restrictions. So, abortion clinics had to have the same size and facilities as broad surgical facilities. Doctors had to have admitting privileges to a hospital within 30 miles, even though the procedure was already safe. And at the oral argument early this year, it was just a brutal interrogation by Kagan and Ginsburg and Sotomayor of the Texas Solicitor General. And, he barely pretended to have a medical justification. It's pretty clear that these were just about restricting abortion. And what happened today was that...
Let me just put a finer point on that. My understanding is that the state of Texas could not even isolate a potential threat, a health threat, that was supposedly dealt with by these restrictions or requirements, right?
Yeah, they could literally not cite a single case in which a doctor having admitting privileges would have led to better care. Among other things, if there's complications from an abortion, it generally happens days after the fact. So, it's not, you'll just go to the doctor closest to your home. You're not necessarily going to go to the doctor closest to the clinic. And if there's an immediate emergency, it's not as if an emergency room is going to refuse to see you if the doctor doesn't have admitting privileges. It just didn't make any sense. And again, literally the Solicitor General cannot identify a single case in which it would actually advance the health of women. That's correct.
And so just to back up a little bit more too, tell us what the disposition of the case was as it entered into the Supreme Court, because this is it had gone to the circuit court, and obviously Texas had prevailed, or was it where was it?
Yeah, that's correct. So the district court judge ruled the provisions unconstitutional. The circuit courts, after 8 years of Obama, have gotten quite a bit more liberal, and after not getting off to a great start, Obama got a lot more aggressive about filling vacancies. But the Fifth Circuit is one of the circuits that's still controlled by very conservative Republicans, and they heard the case, and the Fifth Circuit panel upheld the Texas law. So it came to the court, and that's significant, of course, because we now have an 8-person court. So had the court tied, it wouldn't have mattered to the rest of the country, but in states like Texas and Louisiana and other states covered by the Fifth Circuit, the law would have stood. So it wouldn't have created a precedent. So that it was absolutely crucial in this case to get 5 votes. Because a tie would have led to the law continuing to be in effect. And since the law would have shut down more than half the abortion clinics in Texas, that's a pretty big deal. So that getting Kennedy's vote was really important here. It's not as if this came out of a liberal circuit and a tie means win, but at least the law doesn't go into effect. The Texas law would have been in effect for the foreseeable future had Kennedy not joined with the 4 liberals.
So tell us how how surprising. Well, it's before we get to how surprising it is that Kennedy joined the 4 liberals. Tell us what the ruling said and what was significant about that ruling.
Yeah, and it was very, just Dolly Lithwick has a great piece on Slate today. It's very, it's a very wonky opinion written by Justice Stephen Breyer. It's not, if you're looking for kind of a ringing affirmation of, a woman's right to choose, you won't find it. But like Lithwick, I don't think that's necessarily a bad thing. You're trying to give a roadmap to lower court judges to follow, and you want even lower court judges who aren't necessarily, huge supporters of reproductive freedom to start looking carefully at what states are doing. And what Breyer did was just very methodically go through and basically say Texas claims that it has, so that the current standard the court applies is that to be constitutional, a regulation cannot be an undue burden, so that it cannot have too great of an effect on restricting abortion access, and it has to be for some actual legitimate state purpose. So, the state cannot restrict abortion solely to restrict abortion. It has to be advancing some other interest. And what Breyer just very methodically pointed out was that, it clearly is an undue burden. That on the one hand, the impact of this is obviously huge. It would effectively deny women in Texas, outside of a few major urban centers, any effective access to abortion. That many women would have to drive hundreds of miles, to obtain the procedure. So clearly, on the one hand, there was a major burden, and on the other hand, Breyer essentially said, there is no legitimate medical justification. And I think one really interesting thing, by the way, is that although the dissenting opinions by Thomas and Alito comprise 60 pages, they spent very little time actually trying to defend the law. There's a lot of procedural arguments about why the court shouldn't have taken the case or only applied it to certain cases or whatever. But even the dissenters could barely be bothered to pretend to claim that the law had any serious medical justification. They really, this case was just so extreme, and Texas had so little to argue that it was actually very straightforward. And, that's a big deal because what the court is saying is we're no longer going to defer just because the state says there's a medical interest. That's not good enough. That they actually have to, give us some examples. How would this affect the health of women? How would this advance an interest that is worth the restriction it places on abortion access? And the fact is that most of these kinds of regulations just cannot pass that kind of test. So it's a pretty big deal. It's a win.
So does this change the standard? It seems to me that does not change the standard of undue burden, but it does seem to change the standard of the state having a compelling reason, or am I misreading that?
That's correct. So the court hasn't restored the old Roe trimester framework where virtually any abortion regulation pre-viability is unconstitutional. It's still working with undue burden. But the thing about undue burden is that it's not as if it was inherently inevitable that the undue burden standard had to provide very little protection. It's the language itself is not necessarily problematic. The problem is not so much the standard as the way the courts applied it. And I think for the first decade, because Kennedy sort of perceived that liberals were reneging on the deal, he had a very deferential conception of what undue burden meant. But I think what's happened in the last 10 years is that conservatives have pushed the envelope so far that Kennedy now sees conservatives as being the big threat to his Casey compromise. The way Kennedy sees it is that in Casey, states had to be given more leeway to regulate abortion, but women should still have access to safe, legal abortions pre-viability. And basically, I think Kennedy basically said, the Texas law does not protect that right. It's gone too far. And so that the undue burden standard is still there. The difference is that now that it actually has teeth, the court is no longer saying, any pseudoscience, any bare assertion you come up with counts as a medical justification. They're saying it's not enough for regulation to have the form of a medical regulation. There actually has to be a medical justification that can pass some sort of scrutiny, that the courts are going to take a more careful look and say, well, really, what's your evidence? What is the benefit to women? Why are you targeting abortion clinics even though abortion is safe? And that's, so the standard might be the same, but there's undue burden and there's undue burden. An undue burden standard can be fairly robust, and this certainly, it's still not my ideal place, but it certainly is a big shove in the right direction.
All right, Scott, when we broke, you were explaining to us how the undue burden or the fact that when states attempt to regulate abortion, they must show two things. One, that it does not create an undue burden on women's access to a pre-viable abortion. and two, that the state has a compelling reason to do so. So, I mean, is it conceivable that the state could create an undue burden, as it were, or does undue burden, is that contingent upon the state having a good reason? In other words, could the state create a significant burden on a woman's right to choose, but they have found some, I don't know what that compelling reason would be, but some piece of science that says if women get abortions on Tuesdays, then that's somehow a threat to their health, and so we had to close down clinics on Tuesdays. I mean, if they could prove that there was a compelling reason, could they in some ways burden this right or no?
Well, in theory, I mean, the way I would put it is that prior to today, the undue burden standard hadn't really required compelling justification. That the way Kennedy interpreted it in the 2007 case, Carhart 2, it was almost more like an evaluation of economic regulation. That if there wasn't an outright ban on abortion, the court was going to be very deferential. So really, until now, the state didn't really require a compelling justification. The difference is after today, and the court doesn't use the language of strict scrutiny, but it does suggest that that states need to provide more than just, any medical justification. So that, if there's a burden on the right to choose, I don't know exactly, it's going to play out what the standard is, but clearly the court is sending a message that something like, no abortions on Tuesday, or, any regulation that targets abortion clinics specifically is going to be looked at very skeptically. And the states are actually going to have, real evidence from real experts, real examples. So what I would say is that prior to today, the states didn't really need a compelling regulation for anything but a ban. Now, if not quite, they need something more like that, so that if, Breyer's opinion is applied going forward, it's going to be very difficult for the state to justify regulations that, in any way threaten the operations of clinics or mean that, sort of large parts of the state won't have any abortion providers. That, if the burden is there, it's a much tougher road for the states now.
Is this going to, reopen clinics, or let me put it this way: is this going to cause the repeal of other laws across the country? I mean, are there other examples of this that just did not rise to the Supreme Court, or is this basically basically by setting a precedent, we're going to see other states not attempt to pass these laws, or they're going to get struck down at the district or circuit court level?
Yeah, we're going to see a lot more, that there, certainly states like Louisiana and Mississippi have laws that are essentially identical to this. I mean, Texas isn't even necessarily the pioneer here. And these TARP regulations have, proliferated, and there's certainly a lot of them are going to be struck down. And again, remember, most circuits, as we discussed earlier, are now a lot more liberal than the Fifth Circuit. So that, that's the importance of lower federal courts, that now you have a precedent that gives lower courts a lot more to work with, and, the majority of circuits that are now have Democratic majorities, you're going to see a lot of these state laws get struck down, and the Supreme Court is signaling, we're not going to step in and overrule those decisions. And of course, if we end up with a Democratic majority Supreme Court, which we're still several things have to happen for that to happen, but if that happens after Scalia is replaced, then it's going to move even further in that direction. But even without replacing Scalia, definitely circuit courts are now going to get a lot more aggressive, and a lot of state laws are going to be struck down, and hopefully that will lead to some, abortion clinics being reopened in states where they've been forced to shut down.
Okay, well, let's talk about one of the other rulings that we saw over the past week or so, and that is on the DAPA, or I guess the expanded DACA, which is essentially the expanded Dreamers Act. The administration was seeking what from the Supreme Court?
So, well, basically, yeah, so that a lower court, very briefly, the Obama administration basically laid out an executive order, saying that certain classes of immigrants were just not going to face deportation and could get a kind of kind of a quasi-legal status where they could be confident that they wouldn't be deported and could work. And a district court, not only ruled that it was illegal, but issued a nationwide injunction so that the injunction cannot go into effect. So obviously, what the Obama administration wanted was for the lower court, for that stay to be vacated. So the Obama administration wasn't even necessarily looking for the Supreme Court to rule on the merits, just to allow DACA to go into effect while the courts were considering the issue. And the Supreme Court refused. Just a one-line 4-4 decision said, we just affirmed the lower courts, which had ruled against the administration. So unfortunately, DACA will not go into effect.
And there's no this does not in any way, I guess, implicate the question of the legality of the program, just simply whether or not you should go forward with it while it's being adjudicated.
Right, that's correct. And in addition, and it must be admitted, and I think that, I think we've often been critical of the Obama administration for sometimes moving too slowly. In this case, probably the Obama administration was a little too aggressive, that it went forward with the regulations without giving the usual notice and kind of hearing period, which doesn't necessarily make it illegal, but that was the basis that the lower court used. So it's also possible that if it goes through the notice and appeal process that it could get a 1. But of course, Obama's about to leave office. So, what this effectively means is that it's going to be up to the next administration to decide this case. I think we were pretty confident that if Donald Trump wins, he's not going in this direction. Right. Obviously, if Clinton wins, then she almost certainly will. And I would guess that the Clinton administration would do it kind of with the full notice, and everything, and at least then there won't be the same time pressure. But unfortunately, this means that almost certainly DACA will not go into effect. And that's that has an impact on the lives of a lot of people. But it's at this point, it's basically it's impossible to see the case being disposed of until Obama leaves office. So probably this kicks the can forward to the next administration. So just another thing to worry about in terms of the elections in November.
Indeed. Okay, we just have about a minute or so left. Is there another case out of this round of rulings that we've gotten over the past week and a half that stands out for you as being significant?
Yeah, and I wrote about it at the New Republic, but I was actually more surprised by Kennedy's vote in Fisher, the affirmative action case, than I was in the abortion case. That just various aspects of the abortion case kind of led me to believe that Kennedy was going to vote to strike down at least some parts of the Texas law. Kennedy had never found an affirmative action program to be constitutional before he ruled that Texas's was on Thursday. And, he actually quoted some language from Justice Ginsburg's dissent in an earlier version of the case, basically saying, that, the Texas's program where they let in the top 10% of every high school class, it's race neutral on its face, but it's race conscious. There's a background of residential and educational segregation. And what Kennedy was saying here is that it's kind of silly to say that Texas can sort of, implicitly consider racial factors, but not do so as kind of, one factor among many. That Kennedy basically said that, the state schools have an interest in racial diversity, and they don't essentially have to lie about the fact that they're considering it, and considering it is not like, bringing back Jim Crow or a racial hierarchy. So it was actually a pretty good, liberal opinion, and I was surprised. I was a little surprised by that. And I think, again, that as with happened to abortion, I think Kennedy was just pushed too far by Roberts and Scalia, that, Roberts and Scalia wanted to say you could never take race into account for any reason, and Kennedy kind of said, things are a little bit more complicated than that. And he had made noises to that effect in the past, but this is the first time he'd ever actually put it into practice.
Fascinating. Scott Lemieux, thank you so much for your time today. Really appreciate it. And I guess we'll have more to talk about as we get a sense of who that ninth justice ultimately will be, assuming there is a ninth justice.
Right, which we'll see.
Not necessarily a foregone conclusion. Indeed. All right. Thanks so much for your time today.